While we talk about technology and digital and regulatory and subtech and all of that, I think what's very, very important is to see the reality that we have the emergence of fintech, adtech, OTT platforms in the country. And we need to see how the regulator can be more agile in its approach towards actually promoting growth in the digital ecosystem. In progressive economies, they take a light approach where the regulatory environment is supporting the tech sector. And this is what we need to see in our country as well. So what's very key is that we bring about a balance between regulation and innovation. If we introduce regulations without keeping in mind the potential impact it can have, it can negatively impact innovation and obviously the tech sector. Looking at that, when we take a look at that, driving digitalization in the public sector requires a mindset of openness and transparency, which I felt the SECV just has discussed this today in depth. And three things that need to be taken into account is establishing a digital-first approach, investing in digital literacy within the public sector. We were talking about capacity building and capacity restraints, and developing a robust infrastructure, which means good internet connectivity, data centers, and so on and so forth. And just a comment on what Mr. Jamil was talking about in terms of cloud and data, what's very, very important to keep in mind is that the data sovereignty is something that we should be looking at. Yes, there are cross-border options that we have, but perhaps looking at more a localized cloud which keeps our data sovereignty intact, and perhaps the NTC can work closely with the public in a public-private partnership model where we do have cloud locally as well, but it's definitely owned by the private sector. But through a public and private partnership, we can actually look towards building that capacity within Pakistan. Thank you.
Thank you. Islamabad is here with us. He's a leading, he's running a venture capitalist. Just one word, because we are running out of time. Just one word. They come from Karachi, especially to participate.
Assalamu alaikum, everyone. Thank you so much for having me here. I'll give more of a private sector and investment perspective. What we're doing is today, the presentation earlier, what I talked about in terms of blockchain, data, and RegTech eventually. Pakistan's sitting at a precipice where we're about to leapfrog in documentation. And this is going to come not just from domestic regulation, but international regulation. So if you look at OECD Common Reporting Standards with global mutual legal assistance, where a tax resident, data will be sent back to your country of residency. Subsequently, as FATF, in the garb of anti-money laundering for narcotics and terrorism, in reality, it's pushing for traceability and a cashless system. And so if you were to leapfrog in Pakistan in 10 years, you'll see most cash effectively eradicated. So it would be as certain as long distance that telcos had, and today WhatsApp has disrupted it. It's the certainty is that. It's just the time frame and our will to implement it. As a venture capital fund, our job is to invest in the future and work back. So we invested in companies like Habal, NeaPay, Postex, Adalfi, Abhi Finance. These are all companies that are the building blocks of fintech in Pakistan and will fundamentally change the way that our society functions in 10 years. And I'll leave it with the convergence of AI and blockchain, because that presentation was very profound. That will, in fact, in my opinion, eradicate corruption in Pakistan.
Thank you. Thank you. Mubaraz, you are here with us. Just let us know how technology can help us in resolving the cases pending in the courts expeditiously. Just 1 minute. I'll have to close
need more than one word, but yeah. Essentially, the two ways you can reduce or manage cases effectively using technology. I think we've spoken about.
Introduce yourself first.
Mubarak Siddiqui. I'm a lawyer, work a lot with startups and technology companies. We've spoken about technology quite a bit. What we have not spoken about enough is this emerging field in law, which is legal design, which essentially means that you use more than text to convey law better, which helps with regulatory compliance better. The law is generally hiding behind this great wall of text, and there's a lot more we can do to both explain it better, so that people can understand it, and number two, design processes better, which makes it easier for people to comply. When regulators approach regulatory processes with empathy and with a design-oriented approach, what happens is that they do not require extra documentation, extra procedural compliances, which helps people comply better. Moving on to case management, the emergence of ChatGPT and the way AI has emerged in the past year, every 3 months, the leap has been exponential. GPT 3.5 that came out in November could not pass the universal bar exam in the US. GPT 4, which came out in February, has cleared the universal bar exam in the US. What is required is for us to help that aid and abet us, as opposed to think of it just as a threat. Of course, Zahid was right about this being regulated properly and managed properly, but essentially what we need is to, on an urgent basis, deploy this technology and use this technology to help our courts resolve matters quickly.
Thank you so much. Now I think we are now moving to another segment, sir, which is ADR, much more easier for us to understand this B2B AI, but I think we should be acquainted with it. This is the future that is, we have to handle it at some point. I'll start with Taimur. Taimur, say 2 words.
Ji, thank you for inviting us to this panel. The role of ADR in resolving corporate disputes. There couldn't be a better topic to discuss in today's Pakistan. It's all about the economy, and the economy can't really move if we improve and enhance the enforcement of contracts in the country, and if we improve the speed with which we can resolve disputes. I would say that even though I'm a practitioner of ADR and arbitration, not just in Pakistan, but have been in the Middle East region as well for the last 15 years, that companies should try to avoid both courts and arbitration, because both can be cumbersome, lengthy, and expensive. And there comes the need for initial ADR steps. I would encourage lawyers, and I think in the new drafting that we see even in Pakistani contracts, we'll see pre-litigation, mediation, negotiation, a neutral expert appointment, and so on, before we get to the stage of full-blown arbitration or litigation. And this is really what I would like to say.
Thank you. Thank you. I now request.
That's up. I would only say that
we've been told you don't have the time, so we're trying to fast track. Yes.
No. I just wanted to say that with the judiciary being present here, that although Pakistan is now leading the way in many respects in relation to enforcement of foreign arbitral awards, it still takes too long. So there should be specialist benches and judges who really look into this thing, and matters don't get delayed. I'm dealing with one international award enforcement in Lahore at the moment, and there have been postponements and delays in the last 6 hearings. So that's not normal if we are to compete with the Western world. Thank you very much.
I would request Justice Jawad to say this word.
Bismillahirrahmanirrahim. Honourable Chief Justice Pakistan and honourable judges of the courts and ladies and gentlemen. This last and the most interesting topic is ADR in resolving corporate disputes. The preamble of the Companies Act 2017 is new and a very exhaustive preamble. It itself starts with to effectively resolve the corporate dispute in a speedy manner. When the preamble is read with section 6 of the Act, and then there is part 8 of the Companies Act 2017, dealing itself with the 2 words, 277 with the reconciliation and arbitration, and also the mediation. So 3 things that if the law gives you the sections and the preamble, then most of the corporate disputes can be resolved through the ADR. It can be arbitration if there is an arbitration agreement. Otherwise, there will be then the reconciliation or the mediation. In this sense, that since Article 37D it still states inexpensive and speedy justice, we have done, and there are judgments we are passing. Recently, Lieutenant General Mahmood Akhtar case 2022 CLD 708, which I passed in the Rawalpindi bench, where the section 6 was invoked by me by stating that if the company petition is filed in the High Court, which is now cited most of the cases now in the provinces, that should be decided within the period of 120 days only, because Section 6, subsection 9 talks about 330 days for a party to resolve, and that is because the whole scheme of the law is jurisdiction to the company court under Section 5, then the jurisdiction to the company bench, how it deals with it, with a time frame, and that concept is very, very effective. If the ADR and the time frame are parallel to each other, and the time frame is also as a time-bound specific legislation is the company bench. In the ADR issue, already there are a lot of judgments from the Supreme Court of Pakistan resolving the issue of 3 arbitration with mediation, reconciliation, settlement. We have been doing it as Mr. Kamar was sitting here, who was counsel in those cases, that how courts can adopt in a corporate dispute, first, if there is no arbitration between the parties, asking for the mediation. That could be the first stage, early, what the English commercial courts is doing, a new mechanism which I try to bring in Pakistan is ENE, early neutral party evaluation. When you ask the parties that instead of wasting more time with us, we know there's 120 days, the sort of time with us. If you want to resolve ENE, they appoint a mediator, and that is, you can do the evaluation without touching the merits of the case. And if both the lawyers sit together, and when they know there's jurisprudence against me and jurisprudence for me, they can weigh the jurisprudence of Pakistani courts and they say, let's settle it. So ENE is something very new. I've adopted in 5-6 judgments, and I've also recently published a new judgment on that, early neutral party evaluation. It can be done by the parties themselves under mediation, or the reconciliation. In reconciliation, parties can sit together without the lawyer. In mediation, lawyers are needed. And if the lawyers are needed, they can sit down, and I am giving this thing without the support of law to the SCCP, a lot of ENEs, but then finally I found Section 277, 278 last. I suggest SCCP to give empower the High Court also, because Section 277 says the Commission or the appellant bench can refer the matter to appellate bench. If there will be notification, Commission, appellant bench, or the company court can do that. Thank you.
Thank you, sir. Thank you very much.
Mike, Mike,
well, if, as I'm given to understand, the subject is ADR in a corporate paradigm, all I can say is that perhaps we need to create this culture where we place an emphasis and create this realization that even a bad settlement is more often than not better than a good lawsuit. And I think the system which we are implementing at the moment doesn't emphasize that, and perhaps leaves us prone to unnecessary litigation coming up and clogging the system. We've attended numerous sessions such as this where we've identified causes such as the absence of costs and the reasons for other delays in our system. But at the end of the day, it's a matter of implementation. I think if we identify the problem and then take concrete steps towards addressing those problems, we'll be able to move forward. Speaking from a Sindh High Court standpoint, we have a unique problem, at least which is unique to Karachi. The Sindh High Court enjoys what is called the original civil jurisdiction, which means essentially that it is being force-fed, if you look at it that way, with cases which are not corporate, not commercial by any stretch of the imagination. And we had occasion to examine this in 2 petitions which had come up, and the judgment which was authored by me is perhaps now reported in the June part of PLD. We had looked at the data, and the data shows that as many as 21,000 civil suits are pending in the High Court alone. And if you look at the sanction strength of the court, it's 40 judges. Out of those 40, you can at best perhaps devote 5, a maximum of 6. It's a losing proposition. The pendency will continue to rise even if you were to chain us to our desks and make sure that we work 24 hours a day. It's not possible to correct or address the issue in a rational way. So I think the system perhaps has to be redesigned in a manner which is administratively capable.
To share his thoughts on us on ADR.
The experience of the previous issue.
On ADR. Assalamu alaikum.
हम इनको हमेशा uninformed और वो कहते
Healthy
हैं
gas
in
speech
martial law
carrying
ये
case.
extempore
Carrying
बहुत अच्छी चीज है.
Yousaf ने मैंने कहा
My lord, ladies and gentlemen, as far as the subject of ADR is concerned, we at the Islamabad High Court have been extremely excited about it, at least since the past 1 year, when Justice Yousaf Ali Sayeed and myself went to Turkey and studied their model, and were pleasantly surprised that ever since their statute regarding ADR came in the year 2013, they had decided 3 million cases through mediation. 3 million, that's the correct figure. Pakistan, I doubt, could have even resolved 3,000 cases, especially the Islamabad Capital Territory. We are still looking for that magic wand when sitting in an adjudicating capacity to convince the parties about the benefits of mediation, to refer the matter to mediation. And the trouble with that is that, unlike arbitration, where the court can force the parties to abide by their contract and refer them to arbitration, mediation is consensual. The fundamental basis of it is consent. So no matter how willing one party is for the matter to be referred to mediation, if there is an intransigent opponent, the matter will not be referred to mediation. Just to let you know, my lord, the Chartered Institute of Arbitrators, in collaboration with the Legal Aid Society of Karachi, headed by Justice Khilji Arif Hussain, came to Islamabad and, in collaboration with the Federal Judicial Academy, trained 50 mediators. And out of those 50, about 40 have been certified. They have also been granted permission to sit as mediators by a mediation center that has been duly registered in Islamabad. So we have all the foundational infrastructure available in Islamabad for mediation to be carried out. Now, since a lot has been spoken about technology, these mediators are not run-of-the-mill practitioners, sir. These are young, robust barristers, well-versed in not just the scriptures of law, but also technology. So you have these computer-savvy young mediators in Islamabad ready for cases to be referred to them, whether it is at the level of the Supreme Court, the High Court, the subordinate courts, or even if there are cases at the level of commissioners pending before the SECP, they may be considered. The Islamabad High Court can provide you with a list of these mediators, and I assure you, you will get results if you try them. Thank you.